I'm recording this one too, so we're going live on YouTube. All right, Mr. Lacasse, all right. And I have Mr. Sala. All right, this is in the matter of Michael W. Earles, an individual, versus Michael R. Is it Shute or Shute?
Shute.
Shute. It's completely wrong. So Michael R. Shute, Brenda Baxter Shute, husband and wife, jointly and severally. Russell T. McMordie, Deborah E. McMordie, husband and wife, jointly and severally. File number 22-6966CH. I have Stanley M. Sala, P40145, appearing on behalf of the plaintiff. And I have David E. Lacasse, P71171. And so Mr. Lacasse, is Mr. Stimson appearing today or just you?
Just me, Your Honor.
Not that he's not enough, he's enough. I just wanted to make sure because they were co-counsel. And appearing on behalf of the defendants. This is the date and time scheduled for defendant's motion for summary disposition. And I believe it's also pre-trial as well. Is that correct?
The pre-trial this afternoon, but I would prefer to have the pre-trial today as well. Thank you.
Yeah, we can do it after this if needed.
Okay, all right. So Mr. Lacasse, you may proceed.
Yes, thank you, Your Honor. I'm not going to go over my motion as I'm sure the court has read the motion in response. So I think the court is well aware of the basis for our motion for summary disposition. So I'm going to concentrate my time on responding to plaintiff's response. There's a couple of things here, and the thing I want to stress is this: is that first of all, a C10. This is not premature for a C10 motion. We don't need to stipulate any facts. My point is that there is no factual basis that can be developed based on the claims that Mr. Earles is asserting, namely whether it's a road end or whether he has some property right over this particular access point to Devil's Lake. So that's all that is here at issue. In fact, the argument in the response about that the motion for C10 is deficient is I can provide whatever evidence is I have, and I'm using the evidence that was used in the exhibits of plaintiff's complaint. A couple of things that I want to respond to, though, whether or not the access point at issue is a public road end, whether that's a question of fact or a question of law, that is a question of law. This is an interpretation of a legal document. It's interpretation of language the deed restriction or the language on deeds. This is an interpretation of a contract. In fact, in the Coulter's case, which I cited and provided to the court in our motion, that was relied on heavily by the Township of Grayling v. Berry published case, was the court made a determination on what was a road end and whether Elm Court was a road end as a matter of law on a C10 motion, exactly the same motion that we filed today. So I think it's appropriate for the court to make a determination of what does the language of dedication on the plat actually mean? What is the language on the plaintiff's predecessor in interest deed regarding two boats? What does that mean? I think this is, and whether or not any of these access points in the plat of Horton Beach are road ends are well within the ability of this court to, in our matters of law, and are appropriate for motions for summary disposition. The plaintiffs in their response there is, first of all, they made an allegation that we did not define drive in our motion, and that's not true. We provided a definition of drive in footnote number 4 on page 7 of our brief, providing that a drive is a road for vehicles, especially a scenic one, as in along a park, or a short one as an approach to a house. So drive is just another type of road. As far as defining what a drive is, I think we've provided that. It's distinguished from a walk. Nowhere in any of the documents, either the plat, in any of the deeds, is there a term walk street. I have no idea what that is, or where that comes from, because there's no such phrase and there is no such term in any of the documents that are part of either the plat or in the deeds. It is very clear that the drives, which are Horton Beach Drive and Horton Court, are dedicated for use of the public, not just the owners of the plat, but the public, which includes my clients. And it's very obvious on the plat that Horton Drive and Horton Court are the drives that are being referenced, and the access points that are clearly labeled as walks. They're not labeled as roads, they're not labeled as drives, they're not labeled as courts, they're labeled as walks. They're separate and distinct. So that's very clear. There's nothing in there about a walk street. There is, for the first time in their response, the plaintiff makes a number of arguments as it relates to an easement. Nothing in their complaint says anything about the grant of any easement. As far as the arguments in their case law regarding the maintenance of easements and what an easement grants, frankly, aren't relevant, because nowhere is there any mention of an easement in any of the documents. As far as the public road end, it is very clear, and the statute was actually passed. MCL 324-3011-111B was passed to provide the clear definition of what a public road end is, and the statute is very clear what it is. And as the case in Colthurst stated, which the court in the published case of Township of Grayling v. Berry adopted and referenced that premise, is that what constitutes a road, whether a road end terminates at a inland lake or stream, you look at the plat. That's very clear. And it's not whether or not the access point is dedicated to the public. That's not the definition of what a public road end is. Is it a road that that's dedicated to the public, that ends at an inland lake or stream? And none of the roads or drives of Horton Beach do so. These are walks for access by the public to Devil's Lake. That's what they are. They are not public road ends. And there is in Mr. Earles' predecessor in interest about, which I've mentioned very clearly in my motion or in my brief, that is a restriction that says he can't maintain more than 2 boats for that property. Has nothing to do. It doesn't mention anything about access, doesn't mention the lake, doesn't mention accessing the lake, doesn't say that he gets superior rights out of anyone. If it did, it doesn't mention which access point it is. He has one of 4 that he can have access to, and there's nothing that anyone, let alone my clients, is doing to restrict his access to access Devil's Lake on one of these, on any of these walks. So for those reasons, we would ask the court grant our motion and dismiss this complaint.
All right, thank you, Mr. Lacasse. Mr. Sala?
May it please the court, Your Honor. Clearly, Mr. Lacasse's motion, number one, implies that somehow his client's property is in the plat. Clearly, it is not part of the plat. He says it has the same or similar deed restrictions as those lots in the plat. It is not part of the plat. It is behind the plat. Therefore, the grant of the use of placing boats on the dock, 2 boats and no more, is only applicable to the lots in the plat. And that's what's specifically deeded and attached to our complaint. The parcel of property that Mr. Lacasse's client owns is behind not only the lots on the lake, but behind the houses that are behind the houses on the lake, all part of the existing plat. Therefore, their houses are not in the plat. They are the general public. Now, taking the language of the deed that transfers the right to put 2 boats out there by their plain and ordinary meaning, along with their context and setting, in regards to the case that's cited even by Mr. Lacasse, is that the boats are there. You get 2 boats on the dock. That's each parcel in the plat. And it's specifically delineated in that deed, the lot numbers for the lots that my client owns. Now, in Mr. Lacasse's motion on page 4, he says, Shute have virtually identical restrictions and conditions and deeds conveying property to Shute's predecessors and interests. A copy of the warranty deed conveying lots 44 and 45 of Horton Beach to one of the.
I'm sorry, wait.
Mr.
Mr.
Sala,
Sala.
when you read, and anybody does it, you go too fast, so you need to slow down.
Thank you. I appreciate that. I am going too fast. Page 4, in the first paragraph at the bottom, probably the last sentence. Shute have virtually identical restrictions and conditions in deeds conveying property to the Shute's predecessors and interest. A copy of warranty deed conveying lots 44 and 45 of Horton Beach to one of defendants Shute's predecessors in interest is attached hereto as Exhibit C. But if you look at that Exhibit C, it does not transfer lots 44 and 45. The description shows that it is adjacent to and borders lot 44 and lot 45. It is not transferring any interest of lot 44 and lot 45. So that's misleading in his motion. And that's probably one of the most crucial mistakes in his strongest position. If in fact he was deeded lots 44 and 45, that would be a whole different ballgame. But he is not. His exhibit clearly indicates that it is adjacent to lots 44 and 45. Therefore, he has no right of 2 boats on this dock whatsoever. And it is an easement for all intents and purposes, because that's what the grant is for. That's why the language is in the deed, and that's why it's transferred to our clients. They have a problem with any general public person putting a boat on the dock when they have no right to do that, whether it's a walkway or a road. And I would submit it's a walking road. We can amend the complaint at this point if Mr. Lacasse would like to say that it's a walking road, and it does attach to the road that's dedicated to the public, which is basically a road end, and they're placing their boat and or pontoon on a dock that is provided by my client because he has the 2 boat capacity to do that pursuant to what's been deeded to him. And that's the plain and ordinary meaning along with the context and setting. In other words, what's the purpose of having 2 boat right if you have no place to put it? So they have a dock out there. They've had it in this area for over 15 years, and only the plat owners are putting their boats on. The general public, which Mr. Lacasse has indicated, his client has access rights as a person of the general public, cannot just stop by and boat put their boat on a dock owned by somebody else. That's what's happening here. We have a right pursuant to the easement, and we can amend our complaint to change the language from just indicating that it's a two-boat right. It's a two-boat easement. I think it's basically the same thing. That grant is clearly only to the plat owners. So there is a question of fact as to whether this is a walking road or this is an actual roadway for cars. That's what Mr. Lacasse is trying to argue. You have to show that it's only can be used for cars. That's not true. There's plenty of walking roads. And if it's a roadway, even though it says walk, it can also be a walking road. That's a question of fact. The court can't just say, well, a plat says walk, even though for all intents and purposes, maybe if you went out there and looked at it, you'd say, no, this is a walking road, and it does end in the lake. So those are questions of fact. And again, we have not had discovery yet. There's no affidavit attached to his motion. He's relying strictly on his motion that is not correct in regards to they don't have lots 44 and 45, never have. It's not part of the plat, and they are using a dock that's not theirs, which is basically trespassing. One of the issues is whether or not this statute would apply. The other issue is whether this is a trespass. You can't just, as a general public, stop by somebody's dock and put your boat on there because you feel that you have a right to do that. Maybe they believe that they had lots 44 and 45, therefore they had this transferred to them, but they don't. So at this point in time, I'd ask the motion be dismissed. I certainly think some more discovery is appropriate, and I would go from there.
All right, Mr. Lacasse.
Yes, just as a response, my motion was based on the allegations that were made in Mr. Sala's complaint, in which he alleged that my clients own lot 44 and 45. Be that as it may, frankly, it's not a relevant fact and not a material fact that the court needs to, that we need to worry about, because in my exhibit C, regardless of, and if I made a mistake in my brief, I made a mistake in my brief. But if you look at my exhibit C, as Mr. Sala pointed out, this is a meets and bounds legal description. And it very well may be outside the plat. And if it is, then it is. But it is very clear that it has virtually the same language in the restrictions and conditions as Mr. Sala is claiming gives his client a right to dock his boat on Devil's Lake, which it says no more than 2 rowboats are to be used by the occupants of said lot. So if that's not specific to a plat, it's a mentioned in the deed. So if Mr. Sala is arguing that Mr. Earles' predecessor in interest grants him some sort of right, then this deed in my exhibit C to Mr. and Mrs. Shute, and it's pronounced Shute, by the way, would grant the same right. Our argument is it's not a right. There's nothing in the language of these deeds, nothing that talks about access to Devil's Lake. In the context of the rest of the description. That's why the context is important. All the rest of these are restrictions, the same restriction in all the deeds. You can't put up a cottage less than $1,200. Can't have a garage as a dwelling. You can't have more than one dwelling. You can't have a trailer. And you have to, and your cottage has to be equipped with flush toilet and a septic tank. Those are all deed restrictions and conditions of limiting what you're able to do on your property. And that's the same as this statement regarding 2 boats. It's a restriction that says you can't maintain more than 2 boats on this lot. Doesn't say anything about access to Devil's Lake. And so this the claims for relief that are in plaintiff's complaint There's no factual development that can come through discovery in this case that are going to give Mr. Earles the legal rights he asserts in his complaint. He does not have a superior property right to any of the access points, let alone the one that's at issue. So there cannot be a trespass and or a nuisance as it relates to Mr. Earles. And that's who we're talking about is Mr. Earles' rights. And as far as the road end goes, Judge, I think, Your Honor, I think it is very clear, and the language is very clear in the rules of construction regarding contracts, regarding statutes, are very clear. Is that you look at what's written, and if there's a definition provided, you use the definition, and if there's no definition, you use the ordinary meanings of those particular terms. You don't just add terms to create some sort of an ambiguity that's not there. And it's not ambiguous, it's very clear.
Okay, all right, so thank you both. I'm going to take this under advisement and we'll issue an opinion. All right, so for the pretrial scheduling order, we're gonna set dates, but obviously depending on what the decision is, that could impact. So this is a 22 file. Something, there's no jury trial involved in this, so.
Well, we have not filed our answer yet, Your Honor.
Right. Do you want me, all right, so how about this? How about I set this for another pre-trial, and obviously depending on what happens with the motion, we can address it then. So I am, all right.
Your Honor, I would be.
There already a notice, Mr. Sala, so there should be one. All right, so today is December 12th. It's the first day of the pretrial, and I do not have any other dates with me. Miss McGrain is probably in another hearing, so hold on one second. Let me go grab my book. Doug, I'll be right back. All right, I'm going to set this for another pre-trial on February 13th at 3:40 p.m.
Your Honor, I will be filing an amended complaint because there's no answer. The court rules allow me to do that at this point in time. I will amend it to add that the language that Mr. Lacasse was making reference to, and also that the deeds that his clients own were not transferred to them from Thorben at all. So there's no prior transfer from what I'm looking at. So I will be amending the complaint for that.
Okay. So I'm going to set this for February 14th at 3:40 p.m. Does that day work for both of you?
Happy Valentine's Day.
Mr. Lacasse?
Yes, it does, Your Honor.
Okay, perfect. All right, thank you, gentlemen.
Um,
And
just as a matter, do I have to answer the complaint, or should I wait for the amended complaint, or should I wait for the judge's ruling, the court's ruling on our motion?
Well, Mr. Sala, are you asking for more time than the March date or the February date? I mean, I can put this out farther if that would accommodate all of the answers and amended complaint. I can put it out to March if you like.
It's okay with me, but if Mr. Lacasse would like it out further, that's fine.
March is fine. I just need to know whether I have to issue draft an answer.
So when are you filing your amended complaint, Mr. Sala?
I can have it done before February 14th.
All right, why don't I set this out for March 20 at 1:50 PM? That'll give you time for everything.
And that'll give me 21 days.
Yep. All right, I filled out the scheduling order. We'll get the opinion out.
Okay, what time on March 20th?
That is 1:50 PM.
Okay, thank you.
All right.
Thank you.
Should be all set, gentlemen.
Thank you.
Thank you.